My name is Barbara Collier, and I'm delighted that you're joining us this evening for the first webinar in our series of 5 webinars on legal information for people who have speech and language disabilities. And we're starting this evening with access to goods and services because it's the foundation for a lot of the context we're going to be talking about in the other webinars. We have a lot of people registered for the webinars, so this is, for many people, it's an introduction to our organization, and bear with me when I tell you things you may already know, but Communication Disabilities Access Canada, or CDAC, is a non-profit, Canadian-wide organization. We started in 2001, and we focus on human rights, accessibility, inclusion for people with speech and language disabilities, and you will see that you'll hear me use that term, and you'll see SLD, because we are talking about including everyone, people who use augmentative communication and people who have very, very different types of speech and language disabilities. We work on projects only. That's not because we choose to, it's because we don't have core funding. So we tend to be quite limited in what we can do, but we believe that what we do is terribly important. We're a group of speech-language pathologists, augmentative communication clinicians, legal professionals, accessibility consultants, and people with speech and language disabilities. And if you're not familiar with us, I really recommend that you go to our website and you check out our different projects under projects and the resources that we have there. Tonight's, this series of webinars is funded by the Law Foundation of Ontario, and through a project called Connecting Communities, which is operated by Community Legal Education Ontario. So we're very grateful to the Law Foundation and to CLEO for funding us to provide these webinars to you at no cost. We have, as I mentioned earlier, we have a lot of people registered for these webinars. As you know, you can come to one webinar, you can come to all of them. Once you've registered, you're registered. Our registration has capped at 120. We are delighted with that. It shows a huge interest. And we have people from very many different perspectives here and backgrounds. We have speech pathologists, we have social workers, we have healthcare providers, we have lawyers, we have people with speech and language disabilities, family members, and students. So we have people who are coming to these webinars with very different perceptions, very different background and information about the population and the issues. We don't for a minute think that we're going to please everybody, but what we're trying to do is meet as many of your needs as possible, and hopefully we can refer you to resources on our website for more information. So we're very delighted with the response. We've got people from 6 provinces represented, and many of them, as I say, are coming in on this. Some of them will come in at other webinars, and many of them will also take the recorded webinars that will be available. Presenters this evening, I'm delighted to introduce Brendan Poran, who's a lawyer with Poran Law. He's based in Toronto, and his legal work focuses on issues for people with disabilities and family members. So we're delighted to have Brendan with us this evening. Megan Hines is an occupational therapist. I've worked with Megan for many years, and she works, again in Toronto, with young adults with disabilities and chronic health conditions, and most of her work has focused on helping young adults in transition from family homes to community settings. So delighted to have Megan with us. I'm Barbara Collier. My background's in speech-language pathology and augmentative communication, and I am the executive director, and I also manage all the different projects at CDAC. This legal webinar series we picked a number of topics that we think are very important for this population. So the first one this evening, to set the whole scene, is on access to goods and services, and I'll explain a bit more about that in a minute. We're going to be looking at consent to treatment for people who have capacity next week. And the week after that, we're going to talk about substitute decision making. On June the 1st, we're going to talk about personal support services, and again with a focus on legal issues around this. And on June the 14th, which I want to flag is a Tuesday, not a Wednesday, Pamela Cross will be joining us, and we will be she's a lawyer that's worked with us extensively in the past around access to justice, and she'll be presenting with us on abuse and crimes within caregiving context. So we hope you can come to all of them. The format that we have used is Megan has been very busy talking to people who have speech and language disabilities, talking to clinicians and family members, collecting the stories. We've had a survey out that asking people to contribute their questions and experiences. So this webinar, I believe, is really rooted in reality. It's grounded in reality. And towards the end of the webinar, we're going to be presenting context and questions that have been presented to us, and having Brendan give his legal opinion on that. We will be focusing on Ontario legislation. However, we feel that a lot of what we're saying is probably going to be pertinent in other provinces. So bear with us on that. We had to focus somewhere. We are also, because we have a very diverse audience listening, we can't talk about rights and laws for a population that really has no way to communicate and negotiate their rights. So we want to make sure that in our webinars we balance this in some way by giving you some legal information, but also giving you some communication resources that you can sort of connect up at a later time. We do want you to engage with us. We would like you to type your questions into the chat box, and you can do that at any time, or you can wait till the end. And then, depending, we'll get to as many questions as we can. I want to remind you that this is being recorded, so avoid any personal stories or names and things like that. It is being recorded. Oh, and I should say that the recording of all of these webinars will be probably 2 or 3 weeks after the event. So we're going to send you out handouts and these slides tomorrow morning, and that's to entice people to come. We all know, we get the things that don't turn up. So we will be giving you the prize of the slides, the handouts tomorrow, and then the recorded versions will be on the website in about 2 or 3 weeks, and we'll let you know about that. Today's agenda. So we've got a very full agenda and not a lot of time to cover this. We're going to be talking about access to goods, services, and opportunities. We're going to be talking about accessibility in human rights legislation. Brendan's going to talk about what's available across Canada, but specifically in Ontario. We're going to talk about what communication access means for people with speech and language disabilities. And then very briefly we're going to say, well, what should happen? What should we expect to happen in terms of communication access to goods and services? And what are the different roles and responsibilities of the players involved here? And finally, Brendan's going to address the issue of legal rights when it doesn't work. So we'll all just hold our breath for that. Just to set the scene for all of you, to make sure we're on the same page, many of us who work and know people who have significant speech and language disabilities know that they can experience significant barriers to when they're accessing goods and services, particularly essential services such as healthcare, legal, education, emergency, transportation. We know from our research, in fact, that all of the sectors have been identified as creating barriers for people who have communication disabilities, and that many of these barriers cannot be addressed in a clinic room or by a device or by the person's own skill development. They just can't. What we need are responsive communities, and we need strong legislation that protects the rights of this population to be able to have equal access to goods and services. And in Canada, we're very fortunate. We do have human rights legislation, and that legislation is very strong and benefits many people with different types of disabilities. We already know that people who need sign language have strong legislation in place. People who need ramps to get into buildings, door openers. There's legislation. It may not be perfectly enforced, but the legislation is there. What we don't have yet, but we're working on it, is strong legislation to ensure that people with speech and language disabilities have the same level of access to goods and services. And just to let you know that right now we have been working, the CDAC has been working for 15 years on accessibility in various sectors. We've just finished a 3-year project called Communication Access Now. I know many of you are familiar with this. And that was a national focus on raising awareness and providing consistent messaging around what access means for this population. And we know from that the legislation exists in Ontario and Manitoba. We know that there's a strategy, a disability strategy in Saskatchewan. We know that there's emerging legislation coming from BC and in, actually I'm not sure if it's legislation or strategy, there is a difference. And there's emerging strategy, disability strategy coming from Newfoundland. This is happening. This is a movement. This is where we need to be in order to ensure that we're represented. I'm going to be telling you more about all of that later in the webinar. And the other thing I want to mention, though, at this point is that there is currently the start of a federal or a national Canadians with Disabilities Act that is being fronted by Barrier Free Canada. We strongly support them. We are in touch with them quite a bit, and we feel that we have got a voice with that group. So we're very hopeful for it. So now I'm going to introduce you to Brendan, who's going to give you an overview of the accessibility legislation. So Brendan, over to you.
Thank you very much, Barbara, and thank you for having me this evening. So as Barbara mentioned, we're going to be circulating a copy of the slides and a number of handouts to you, I believe Barbara said tomorrow morning. The first handout is going to provide you with a list of the various pieces of legislation that are identified here on the slide, as well as some website addresses for you to sort of explore the legislation if you're so inclined. So what I'm going to do now is sort of take you through, spend a few minutes on each of these laws, starting with the UN Convention on the Rights of Persons with Disabilities, followed by our Canadian Charter of Rights and Freedoms. We'll speak for a few minutes about provincial human rights codes, accessibility legislation here in Ontario, namely the AODA, or the Accessibility for Ontarians with Disabilities Act. And as Barbara just mentioned, there appears to be a Canadians with Disabilities Act in the works as well. So beginning with the Convention on the Rights of Persons with Disabilities, commonly referred to as the CRPD, this is an international treaty, that was implemented or brought together by the United Nations with the intention of protecting the rights and the dignity of persons with disabilities. Canada signed on to adhere to the provisions of the CRPD back in 2010. So we're just over, or we're about 6 years into it, because I believe the ratification actually took place in May. And the idea with an international convention, when a country signs on and ratifies an international convention, is that all of the country's domestic legislation, the country is essentially saying that we agree that all of our domestic legislation will be consistent with the provisions of this international treaty. So the treaty covers all sorts of areas of life, including work and employment, habilitation and rehabilitation, respect for family, right to health, right to education, access to justice, accessibility, and legal decision making. So what we're essentially saying here in Canada is we agree with everything in the convention, and we're going to do everything that we possibly can to ensure that our legislation at home complies with this legislation. So work is hopefully underway by the federal government and by the various provincial governments to amend legislation where needed to ensure that it does comply with this international treaty. Moving on to the Canadian Charter of Rights and Freedoms, which I'm sure that most of you are already familiar with. The Canadian Charter of Rights and Freedoms is essentially a constitutionally entrenched set of rights and freedoms that are applicable to all Canadians. It's the supreme law of the land, and what this essentially means is that all of our federal laws, all of our provincial laws, and all of our municipal legislation must comply with provisions of the Charter. So we can't enact a law here in Ontario that violates, let's say, the equality provision that we identify here on this slide, which is Section 15. All of our legislation must comply with this provision. Section 15 is a very, very powerful piece of legislation. Essentially, what it says is that all of our laws must treat all Canadians equally, and there are protected grounds that are identified, and two of those protected grounds are mental and physical disabilities. So essentially, none of the laws here in Canada, in Ontario, or even down to the municipal level can have the effect of essentially discriminating against a person with a mental or physical disability. Section 7 is also a fairly powerful piece of legislation, and what Section 7 refers to is the right that everyone has to the life, liberty, and security of the person, and the right not to be deprived of these rights. And so we've often seen a number of cases over the years that have touched on or been focused on disability and Section 7. Okay, and then, if we're thinking about this from a hierarchical standpoint, we've got the Charter up top, and then just under the Charter, we've got provincial human rights codes, as well as a Canadian human rights code. So each province has its own human rights code, and human rights codes are what we call sort of quasi-constitutional in nature. So what that means is that the human rights code trumps every other piece of legislation, including the AODA, including the Accessibility for Ontarians with Disabilities Act. And the idea with human rights codes is that they are there to protect everyone's right to equal treatment. There are a number of identified grounds as well with the Human Rights Code, including age, ancestry, citizenship, ethnic origin, place of origin, creed, disability, family status, marital status, gender, the right to public assistance, record of offenses, sex and sexual orientation. So I guess really for the purposes of this webinar here tonight, what the Human Rights Code essentially says is that in the areas of service, goods and facilities, housing, accommodation, contracts, employment, and vocational associations, individuals with a disability cannot be discriminated against. The Human Rights Code also requires that a provider or employer they've got the duty to accommodate an individual to the point of undue hardship. So what this means is if I've got a disability and I require some form of accommodation, let's say at my place of work, for example, let's say I due to my disability, I require flexible work hours. My employer is legally obligated to accommodate my request to the point of undue hardship. And what undue hardship means is, only if it has a significant adverse impact with respect to the employer's cost, or if it results in some sort of safety issue, those would be sort of the only two justifications or reasons that the employer in this example could use to not accommodate my request. It's important to note as well that the code is remedial and complaint based. So in order for the code to have effect, if I felt that I was discriminated against, I would actually have to file a complaint before the Human Rights Tribunal. I would have to initiate the complaint in order to see the action move forward and hope that the dispute gets resolved. And moving on to the AODA. So as I mentioned earlier, the AODA is the Accessibility for Ontarians with Disabilities Act. The AODA was enacted back in 2005, and it's actually a successor legislation to the ODA, the Ontarians with Disabilities Act, which was similar in nature, but it didn't really have as much teeth as the AODA, and it didn't apply to the private sector. So in 2005, the government enacted the AODA. The goal of this legislation is to make Ontario accessible by the year 2025. So we're sort of 11 years into this, I guess about 9 years away from 2025, and I think we have seen some progress, but we still have a long way to go. The province hopes to achieve this goal through the implementation of various standards or regulations. And a number of these standards have been rolled out already in the areas of customer service, information and communications, employment, transportation, and we've also seen amendments to the building code as well. Unlike the Human Rights Code, which is a complaint-based piece of legislation, the AODA is really meant to be more of a carrot rather than a stick. It's meant to educate the general public, educate providers and businesses and organizations by sort of taking this proactive approach to compliance. So there are many comprehensive resources online to assist organizations with becoming compliant with the AODA, and so we strongly do encourage organizations, if they haven't already implemented their AODA policies, that they do so. There are some within the legislation. There are some fines. There are fines built into the legislation for non-compliance. We have seen the License Appeal Tribunal award or some of these fines over the last couple of years, but we haven't seen much enforcement of this legislation to date. We are finding that many disability groups are benefiting from the AODA through raised awareness, and the reason that we're seeing this is because the various standards impose a number of requirements on all businesses in Ontario. So depending on the size of your business, you're required, well, actually all businesses are required to have accessibility policies and procedures in place. Depending on the size of your business, those accessibility policies and procedures must be in written form. So for example, when it comes to customer service, so if there's a business out there that interacts with the public, and as long as that business has more than 20 employees, they have to have a written accessibility policy in place with respect to their customer service. And that written policy would cover things such as the use of service animals or support persons or notice of temporary disruptions. It has training requirements. It has provisions related to the accessibility policies and procedures themselves. So all businesses are required to have this. Businesses with greater than 20 employees, again, must have it written. So if you're ever looking to inquire with a business about their accessibility policies, I would simply ask them for a copy or jump on their website and see if it's posted. Again, depending on the size of your organization, businesses have to educate their staff about accessibility. So again, using customer service as an example, as long as your business has more than 20 people, you must provide training to every staff member that interacts with the public. You've also got to train individuals in your organization that are involved in policy development, as well as your board members. Within the other standards, and again, depending on the size of the business, there's mandatory human rights training, mandatory training on accessible employment policies, on accessible policies when it comes to information and communications as well. And finally, again, depending on the size of your organization, the business would be required to report their accessibility policies to the Accessibility Directorate of Ontario, which is a government agency responsible for the AODA. So there are mandatory compliance and reporting protocols in place where businesses are essentially signing off on confirming that they are meeting the requirements of the AODA legislation. Okay. And so now we'll turn it back over to Barbara.
Thanks, Brendan. Thank you. That was very interesting. I want to talk a little bit about the AODA now and people with speech and language disabilities and what's in it for us. And basically, there are some good things. We've been involved. I've been on the customer service committee developing the standards and been very involved since the start of it. There are some good things there. There's some good information that benefits our population in terms of showing respect and attitudes towards people with disabilities. There's mention of the fact that people often use different communication methods. And there's also mention of support people for daily living, and then also support people who assist communication. And I kind of think that we can use that. I know we are needing and wanting to have trained communication assistants and that they don't exist in Ontario right now, but we do have communication intermediaries, and to me that's something that we can capitalize on, the need for speech language pathologists trained as intermediaries to assist people communicating with police, within justice, within capacity assessment. So we've got some things that I think we can build on there, but the reality is that it's not strong enough. It mainly focuses on people with sensory and mobility and cognitive disabilities. And in fact, we did an analysis, a word count of 7 government provincial documents on accessibility. and there were approximately 400 words or references to mobility, 400 to sensory, and seven in the 7 documents referred to speech and language disability. So there's tremendous lack of awareness of the needs of this population, and the focus is very much on mobility and sensory and websites. When we talk about information and communication, they call it communications, which tells you something. It is about getting information into someone's head. They do not address face-to-face interactions, telephone communication, group communication, and written communication, things that are often very difficult and huge challenges for people with speech and language disabilities. Having said that, we are in a lot of contact with the Accessibility Directorate, and recently, in January, we submitted a brief to strengthen, basically a brief about amendments to strengthen the AODA for people with speech and language disabilities. I don't want to take the time to go into that right now. It's on our website, because any of the documents, the feedback we gave to the provinces are all on our website for people to see. For those of you who are not in Ontario, there is more in place in the AODA than in any of the other documents, so it's not a good scene. So you can see that on our website. I want to be very clear when we're talking about communication access that we're on the same page. When we talk about resources, we define communication access as meaning understanding what other people are saying. And that can be a challenge for people who have aphasia or cognitive disabilities, difficulty processing what other people are saying. Having our messages understood by other people accurately and authentically. Using our preferred methods of communication, which can be speech, unclear speech, it can be a communication board, pictures, symbols, letters, it can be a communication device, it can also be human assistance, somebody to assist you communicating. It means being given the time that you require to be able to communicate your message as completely and accurately as possible. It means being able to communicate over the telephone or use an alternative to the phone. If email or text is easier for the person with a speech and language disability, then those accommodations should be put in place. Being able to communicate at meetings and public events, and if that means having a communication assistant to assist there and having the agenda ahead of time, they're the accommodations that go with that. Being able to use, read, and understand text and e-communications and website navigation, and being able to sign documents, complete forms, and take notes. That's a very quick overview of what we mean by communication access. But that's the background. When we now talk about what should happen, what can we envisage happening? What happens in a coffee shop is different than what we would expect to happen in a healthcare facility. And so when we talk about generic access to generic businesses like coffee shops and retail, what we expect is that people engage with somebody who has a speech and language disability, and that the person with the speech and language disability gives instructions to the individual on how to make communication go smoothly. So in other words, a card that says, this is what I want you to do. I need you to give me more time as an accessibility accommodation. It's not about, this is how I communicate, though that's important. It's more about, this is what I want you to do. And that the service provider follows the instructions. These sound simple. Simple isn't easy. These are education. I think they're actually much more difficult than putting in a ramp. But this is what we're talking about. And when Brendan talks about training being mandatory in businesses of a certain size, I can tell you that communication training is not included in the quick package that people often get around to tick a box and say we've trained all staff in accessibility. It is typically around mobility and sensory and respect. And as many of people I know who have speech and language disabilities tell me, respect does not get you the health care you require. It's a nice beginning, but it's not everything that they need. In critical situations where communication is essential, we expect much more. We expect policies and procedures that are designed for people who have speech and language disabilities. We expect staff to be trained. We expect to have emergency communication systems in place in some of those situations. We expect to have communication intermediaries and communication assistants available within those situations. So it's a much higher level. I want to refer you to our resources about making this happen. And we're working on a number of levels. We've got lots of guidelines and toolkits on our websites. We have messages for policymakers and legislators. We have messages for businesses and organizations about how to make their services accessible. We have toolkits for people with speech and language disabilities on how they can negotiate and communicate about their rights. And we have information for communication clinicians, family members, and advocates to assist people to learn about their rights and how to negotiate their rights. We're going to be giving those to you in a handout, and all of our resources are free and they are on our website. So now I'm turning it back to Brendan, because now I want to ask Brendan, what do you do if it just doesn't happen? So Brendan, take it away.
Sure, thank you, Barbara. So when it doesn't happen, what are your options? And I want to spend a few minutes walking through a couple of those options. I mean, obviously the first point that I'd like to make is that every situation is different. Your options may differ depending on whether or not you're filing a complaint, let's say at your place of work, or if you're filing a complaint with a service provider or with a retail outlet. A lot of this is really fact driven. But we have a couple of tips here that we've sort of included on the first slide. The first one is have your instructions typed or programmed into a device. So this would sort of help from a communication standpoint. It'll assist you with conveying your instructions and your sort of intentions to the third party. We have provided this advice to a number of people in the past, and quite often it has been successful. Deal directly with the problems. So I mean, I think, you know, the question really becomes how do you deal with the problem, and we're going to sort of walk you through a couple of different options in just a few minutes. I mentioned earlier that all businesses in Ontario, in response to the provisions of the AODA, have to have accessibility policies in place. If they are interacting with members of the public, they've got to have an accessibility policy that's specific to customer service. So if you are experiencing an issue, again, at a store or with some service provider, with a government agency, it would be helpful to ask them for a copy of their accessibility policy, so you're able to assess and evaluate how they should be handling the apparent barrier that you may be facing. In terms of the third party's response, so if you make your request and you get a response, and the response is generally stating that they are refusing to accommodate your request, or they're refusing to provide the service or the goods, ask them to put it in writing so that you have a paper trail that you can use for the purposes of recourse, whether that recourse is filing a non-compliance report with the AODA, filing a human rights complaint, going to the Ombudsman's office, or pursuing the matter internally within the organization. It's very helpful for you to have the third party's response in writing. In terms of taking it further, and I've touched on a couple of these as well, we've sort of identified three options. One is filing a human rights complaint. The second is a report of non-compliance to the Accessibility Directorate of Ontario, and the third is filing a civil action. We're going to sort of focus on the first two here. A civil action really means initiating a claim in court. So filing a claim for damages against the third party that has discriminated against you. Civil actions, I would say, are generally a last resort. They are often very time-consuming and can be quite expensive as well. So let's talk a little bit about filing a human rights complaint and a report of non-compliance with the ADO. So depending on the response that you receive from the third party, the third party may actually be breaching the Human Rights Code. So remember, earlier in the webinar, I was talking about the grounds that are protected in our Human Rights Code, and disability is one of those grounds. So let's say that you were requesting that the third party interact with you by way of text or by way of the use of an iPad or something like that, and they refuse to do so. Arguably, they are refusing to meet your request for accommodation. And remember that they have a duty to accommodate under the code. So there could very well be a breach of the Human Rights Code there. And so how do you pursue that? What do you do? Well, you'd essentially be considering filing a claim or filing a human rights complaint before the Human Rights Tribunal. What we would recommend you do in terms of a first step is consider seeking legal advice from a lawyer or from the Human Rights Legal Support Center. So there is a publicly funded Human Rights Legal Support Center here in Ontario to help complainants initiate their claims, and the HRLSC provides a wide range of advice. It may provide you with some summary advice and say, you know what, we think you have a claim here, we don't think you have a claim here, and here's what we think you should do in terms of next steps. In some cases, they actually they actually take on your case and they represent you before the Human Rights Tribunal. So I would recommend as a first step that you do call the Human Rights Legal Support Center. You can find their contact information online. We've found them to be extremely helpful over the years. Over the past, I think they've been around for about 8 years. Alternatively, you could seek advice from a lawyer in the private bar. Typically, however, you would sort of have to be prepared to pay a fee for that advice, whereas the advice that you're receiving from the Legal Support Center would be free of charge. In the package that we're going to be circulating to you, there are a list of Ontario legal resources in handout number 5 that you could also consider referring to when deciding whether or not to file a human rights complaint. In terms of filing the human rights complaint, but before you do so, once again, I just want to stress the importance of seeking legal advice, because it may very well be that while the third party's actions were disrespectful, or they were a violation, let's say, of your dignity, it may not necessarily result in a human rights claim. So seek some legal advice before you move too far down this path. And I would strongly encourage you to seek legal representation as well. I know that this could often be difficult due to the costs associated with legal representation, but again, it may be worthwhile calling the Legal Support Center to see if they would be willing to provide you with some form of representation along the way. Consider the respondents being the third party, the party that you are bringing a complaint against, the grounds on which you are basing your claims. So we've often reviewed human rights complaints, and sometimes the ground on which the complainant is claiming to have been discriminated against is not clear. So there are checkboxes, there are places to identify on the Form 1. There's a place to identify the ground on which you are relying, and typically, I mean, most of the work, at least that we're involved in, the ground on which the complainant is relying on is disability. Think about the remedies being sought. So are you looking for monetary damages? Are you looking to be reinstated into a place of employment? Are you looking to force the third party to undergo training? Are you looking for an apology? So you can sort of seek advice with regards to remedies from a lawyer as well. Consider what documents are going to be required. And I remember I said sort of a few minutes ago that it's important to sort of get third-party responses in writing. Well, you know, that document, that note that you made, or that note that was provided to you, would very likely ultimately end up becoming documentary evidence should the hearing move forward. Consider what other documents would be required in order to strengthen your claim. Consider whether or not you're going to require witnesses. Is there witness testimony that would be advantageous to your claim? Mediation is often highly recommended. So when you file your claim, there's an option for you to go to mediation first. And generally speaking, that's a good idea. Both parties sort of meet informally with a member of the tribunal, typically separated in two different rooms, and the tribunal member goes back and forth trying to mediate the dispute and resolve the dispute without the process having to escalate to the hearing stage, which again could take quite a bit of time and could be quite costly. Typically, when you initiate your claim, you're looking at probably about 6 months for a mediation date, and close to a year if the matter were to go to tribunal. You can also, when completing your application, identify whether an accommodation would be needed during the process. And so again, you have an opportunity to do that on your Form 1, and we've got a bullet. The third bullet there says complete application. The application is called a Form 1, and there are some supplemental forms as well if needed. There are various ways to submit your claim. You can submit online, by facsimile, by email, or by mail. Keep in mind that if you do have legal representation, it would be your lawyer that would be submitting the claim on your behalf, so you wouldn't have to worry about the logistics of doing that. A couple of further points with regards to a claim. So a complaint could be an arduous task. So I sort of simplified the process there, but it isn't as easy as simply completing a form, sending it in by email and hoping that your matter gets resolved within the next month or two. It does take time. It often does require a lot of evidence. If it does get to the tribunal, it may require witnesses. Again, I strongly recommend that you do try to seek legal representation, because it would, in most cases, significantly improve your chance of success, or at least of a mediated settlement. And then we've got a third bullet there that says consider multiple applicants. So you know, if the matter does involve a number of individuals, then it may be worthwhile considering whether or not you all wanted to file a claim. It may add some strength to the claim as well. So that was sort of an overview of how you would go about filing a human rights complaint. In terms of addressing the action or the discriminatory action of the third party within the arena of the AODA, or the Accessibility for Ontarians with Disabilities Act, it's important to note that individuals can't, unlike the human rights system, individuals cannot file accessibility complaints under the AODA. They can't file individual accessibility complaints, but they can report violations of the AODA to the ADO, the Accessibility Directorate for Ontario. The directorate could investigate and impose fines in cases of non-compliance. So you know, it's not like the human rights system where there would be a complainant and a respondent. You would simply be reporting a violation. That violation may or may not be investigated, and it may or may not result in a fine. As I mentioned earlier, we have seen fines for non-compliance handed out over the last couple of years, mainly due to businesses not filing their accessibility reports or their compliance reports, and those fines have generally been in and around $2,000. The AODA does also include provisions for more serious offenses, and those penalties actually can be as great as $100,000 a day for the business, or $50,000 a day for each director of the business. As I mentioned earlier, though, the AODA isn't a complaint-based mechanism. It's really meant to encourage businesses to become compliant, to expose them to accessibility issues, and to encourage them to remove barriers to accessibility. So it is really meant to be a carrot rather than a stick.
Okay. Thank you, Brendan. I'm just going to jump in there before Megan. Did I interrupt you? Did you want to say anything else?
Oh, no.
No, I'm talking to Brendan. Yeah.
No, that was it, Barbara.
Okay, yeah. Thank you so much. Just a couple of things that I wanted to mention. CDAC has been meeting with the Ontario Human Rights Commission around issues for people with speech and language disabilities, and we've also been quite involved with the Human Rights Legal Support Centre. We've done trainings for them, and we're exploring some issues right now. What I would like to suggest is that follow us on Facebook. I can't give you the details at this stage, but we have meetings actually this week. But follow us on Facebook for some interesting developments. And if you want to go forward with a human rights complaint, you want to do a multiple complaint, it's probably advisable just to touch base with us at CDAC, because we may be aware of some of the things in the works. So I just wanted to say that. Regarding the AODA enforcement, there's some very strong advocates for stronger enforcement out there. In your handouts you will get a connection with David Lepofsky, the Alliance for AODA, and some of the things that he's recommending, and also recommending within the Canadians with Disabilities Act, much stronger enforcement. And we've also been in touch with the Accessibility Directorate in terms of informing them about what a violation might look like for somebody with a speech and language disability. So it's quite loaded. There's not a lot in place right now, as Brendan said. I'd like now to introduce Megan. Megan is going to pose some questions that she elicited from her discussions with people. So over to you, Megan.
Okay, so first off, I really want to thank everyone that I interviewed or interacted with for speaking really candidly about some difficult and frustrating circumstances. And we obviously can't cover all of the stories that were told to us or all of the situations, but the foundation of many of them were difficulties with access to goods and services, and we're going to present a few key stories from some critical areas. So this is a story about retail. I was trying to ask if they had a piece of hardware I wanted. I tried to spell it out on my letterboard, and they thought I was begging and asked me to leave the store. So we heard many stories along this sort of variation where no service was provided at all in retail settings.
Brendan, would you like to respond to that?
Sure. So, in this situation, one of our earlier pieces of advice was to try to get the third party statement in writing. Obviously, here they're not entertaining any form of communication, and so it would be difficult to make that request. What I would suggest is, as you do leave the store, take notes immediately. So take some notes, record what happened, record where you are, time of day, the nature of the dispute. So what happened, what was the response, and make sure you just cover all of the details that surround the encounter. In this situation, I would recommend that you call the Human Rights Legal Support Center and seek some advice, because there is an obvious breach of the Human Rights Code here based on disability. Again, the store has a duty to accommodate. They're only the only reasons they have to, the only defenses they have to accommodating are really based on, again, on cost and on safety, and here neither of those apply. So call the Human Rights Support Center, have them sort of verify that based on your account of the situation that there was a breach here. And I would ultimately consider filing a complaint through the human rights process.
Okay, thanks. I'll move on to the next story. So we definitely heard many stories about healthcare settings, and obviously we expanded out to 2 other webinars to cover capacity and consent issues. But even just basic accommodations in healthcare settings seem to be a common theme. So here's one. Due to my physical and communication disability, I couldn't use the hospital call bell or call the nurse when I wanted attention. They took my device away and locked it up in the nurse's station, and I had no way to communicate with them. So what would your response be, Brennan?
Mm-hmm. Here, the response may be somewhat similar, although there may be a couple of other options here. I mean, one is if there is a way to somehow request the nurse's direction, or in writing, that would be helpful. Again, if there's any way, if you have any kind of device or any means of recording what happened, you want to record the details, time of day, the response from the nurse, your attempts to convey to the nurse the need for the device. Most hospitals do have an internal means of filing a complaint, like a customer relations division. So you may consider initially pursuing that avenue. I think you would definitely want to ask the hospital for a copy of their AODA policy. Have a look at the policy. If it appears that the policy was violated, which it likely was here, you could consider filing a report of non-compliance with the ADO, but that isn't really going to remedy what happened to you there. Your recourse here, again, is really through our complaint-based human rights systems. So Again, consider contacting a lawyer, seeking some advice, calling the Human Rights Legal Support Center, and speaking to them or communicating with them about your potential claim, and consider pursuing the matter that way.
I just want to jump in there and say we can't cover everything in this webinar, so we're really focusing on your legal responses to this, Brendan. But I want to highlight that next week and in the other webinars, we're going to be really talking a lot about if these are the things that are happening to people, and these are not made up stories, these can happen all over to anybody, then we play an enormous role as communication clinicians to assist people to anticipate these problems, and to have doctor's notes that says I need my communication system, to have communication intermediaries in these situations, to have their accommodations typed up and obvious so that this doesn't happen. And we will talk more about that next week, but I don't want to get sidetracked on the communication solutions to this stage. At this stage, I want to, though we are aware of them, I want to keep it focused on the legal stuff. So I just wanted to highlight that. And Megan, over to you.
Sure. Okay, so we definitely heard this in a variety of settings, that people assume that the person who has a communication disability is incompetent and put all sorts of restrictions on them because of that. So this one was the paratransportation service wanted to have a person accompany our clients. Our clients are adults and capable of their own decisions, but they use communication boards or devices to speak. The driver felt that they weren't capable of traveling independently and told us that they needed to be accompanied. So Brendan.
Okay, yeah, and so again here, I mean, to Barbara's point, first of all, I mean, if there was a means for you to have your accommodation typed up and ready for the driver to see, I mean, that would be sort of the most proactive way of trying to address this matter before it even becomes an issue. If the driver is still unwilling to allow you to travel unaccompanied, the advice would sort of be fairly similar. You can jump on the transportation services website, or give them a call, or somehow seek out their AODA policy. They should have one in place. Consider filing a report of noncompliance with the ADO, but again, that isn't going to remedy your specific situation. So we again go to the human rights process, and the recommendation that you do seek some advice. I'd start with the Human Rights Legal Support Center and chat with them a little bit about the situation. This situation is a little bit different because than the first two, because the third party here, the paratransportation service, would likely argue that the duty to accommodate here wasn't possible due to safety concerns. So if you decided to file a claim, you would have to be ready to sort of respond to that, and to have enough evidence in place to address their possible defense.
Okay. So I'm just going to go on to the next one here. So this came up a lot in terms of various service providers, but ODSP in particular. I wanted to discuss my ODSP, and the only way I could do this is over the phone. My ODSP worker didn't understand my speech, so I asked my mother to interpret. They told me that they would not accept that, and if I wanted my mother to assist me communicating, I would need to give her power of attorney over my affairs. I can take care of my own affairs, they just needed help to understand my speech. So I had a variety of variations on that theme in terms of stories, and in particular with ODSP.
Sure. So this is absolutely not true. If a person is capable of managing their own affairs, there is absolutely no reason for a power of attorney to be in place in order to authorize somebody to help with communication and interpretation. All the individual would be required to do is send ODSP a consent and authorization form. So essentially a simple note that says I consent and authorize my mother to participate in communications with ODSP on my behalf. And ODSP should adhere to that request. There's absolutely no reason here to go the power of attorney route. If any third party, I shouldn't say if any third party, but generally speaking, if any government agency continued to refuse to or require these documents, then I would escalate it. I would escalate it to the manager of ODSP, perhaps to the director of ODSP. And ultimately, once again, if you couldn't get this matter resolved, although I would be very surprised if you couldn't get this matter resolved with a consent form, your recourse, once again, would be through the human rights system.
Right, and I would add that from personal experience, you can get access to their policies about accommodations, and that you can often meet in person with them at the beginning of your services or at any point to sort of work out what accommodations you do require as well.
Absolutely.
So, communication support. So this is just in general. This came up for a variety of settings where people want someone to provide assistance. So sometimes I need assistance to help me communicate with other people, like the doctor, wheelchair vendor, police officer, and others. They don't know how to communicate with me. Can I ask for this? Who would help me, and who should pay for these services?
Mm-hmm.
Loaded question.
Yeah, this is a bit of a difficult question. I mean, I think it does depend sort of who you are interacting with. I mean, from I'm assuming here, Megan, we're talking about in terms of assistance, it would be a professional that the individual is seeking assistance from, correct?
Yeah.
Yeah. So, yeah, I mean, sure, you can ask for this. Let's start with that, and I think the response again is going to vary depending on who you're speaking to. If you're going to see your doctor, or you're dealing with a small business or a mom and pop shop, I mean, they're likely not going to be willing or in a position to pay for that assistance, nor are they necessarily obligated to do that if you're dealing with
if I can just jump in, Brendan, yeah. I think that I agree with you. I think, and perhaps this is a little bit confusing, I think there's a difference when it's a public service. So if you can, I would parallel this with any public service and their right to provide sign language services when somebody needs assistance. So that would be when police, healthcare, any of that. But also, we know that financial services have an obligation to provide that. It doesn't seem, there seems to be difficulty knowing where the boundary is. If a private lawyer or a private doctor or a private, it's confusing. I'm not sure.
It is confusing, and I can't really point to any particular piece of legislation that obligates any third party to necessarily provide this. I would start by asking for, again, their AODA policy and having a look at their AODA policy and seeing what the customer service policy says, if they do allow for this for interpretation services. I mean, ultimately, if they refuse, the only recourse is really again, unfortunately, and I'm sorry to keep on going back to this, but filing a human rights complaint, keeping in mind though, if you file a human rights complaint, let's say against a sole practitioner, you know, a lawyer or a dentist or you know, any kind of small business, that they're likely going to again rely on the fact that they are unable to accommodate due to cost, right? That it isn't within their financial means of consuming.
All public services under Eldridge say that the communication must be supported. So I think that public, I think we have something to fall back on. What we don't have are necessarily the support services in place.
That's right.
But I think that's very interesting. I'm going to move this along, if you don't mind, because I want to make sure that we have some time
for questions. Exactly.
For questions.
The last one.
Just to summarize before we open up for questions, I just want to make a point that, yeah, there's not a lot of legal options that aren't arduous and time-consuming and expensive right now. It's not a good thing, and I think it's true to say that we're still at the point where we're battling one access barrier by one person at a time, and that's got to change, and it's got to change through education. But I think also it's a real wake-up call that we have to have stronger legislation in place to protect people with speech and language disabilities, and we have to have directives in place. We are calling for directives within hospitals, within our directives went out, again, request to Justice to put communication intermediaries in place. We have been lobbying the Ministry of Health to put in accommodations for people in medically assisted dying situations. That none of these decisions can be made without accommodations. But I think we have to be a lot louder in doing that. And the stories that we're hearing are, I think, systemic. It's all through the system. So there's a lot of things that we I think are uncovering in this webinar and these discussions. I would now like to, I'm cognizant of the time. We will be sending you these handouts tomorrow, hopefully, and a copy of all the slides. And we also will be sending you a link. We really want your feedback. It's very important to us and to our funders that you give us feedback, you tell us what you liked, you didn't like, what you'd like more about, what questions you have, all of that. And now, Megan, we have a few minutes left. Were there any questions from participants that you'd like to bring forward?
So I'm going to start with the questions that were typed during the actual webinar. So there was one that was a fairly simple question in terms of how does the law protect persons with communication disability with regards to employment interview process?
Well, there are a couple of pieces, and again, we look to the AODA and the Human Rights Code. So there is an employment standard in place now under the AODA, and the employment standard essentially says that the entire employment process has to be accessible, right from recruiting through to termination. So that's one piece. I mean, you can ask for a copy of the organization's employment policies, but again, you're looking at the complaint-based mechanism, which is the Human Rights Code. So if you feel that you are being discriminated against in the human rights process, then again, I would recommend that you consider pursuing the matter through the Human Rights Tribunal, again, perhaps by calling the Human Rights Legal Support Center first.
Okay. Okay.
Any other questions, Megan?
Yep, there's a question from Gail Fisher-Taylor. What are the AODA accessibility requirements for an organization or a retailer which does not have 20 employees or more?
Oh, they're on the website. I'm just going to jump in there and say that all of that information is on the AOD website. Isn't that right, Brendan?
That's correct. Yeah, you can easily sort of locate that information on the site. I mean, generally speaking, from a customer service standpoint, If there are less than 20 employees, then the organization isn't required to have written policies in place. They are required to have policies, but not written policies in place, and they're not required to deliver training to their staff.
Okay.
Megan, is there any question?
Yep. So Bobby, oh, I'm not even going to attempt it because I'm going to mess up the last name.
It's only just a few more minutes, so.
Yes, okay. In the case of a lawyer denying the right of a client to change his will due to a perception of lack of capacity, can the Consent and Capacity Board be brought in to help?
I'd like to say that we are going to be discussing that next week. So can we defer that a question?
Certainly. I believe one more person is typing a question right now. I can see them actively typing, but there aren't any other questions on the board, more just discussion. So I'm just going to see, is there a deadline to file a complaint, like a human rights complaint, I'm assuming? This is from Elizabeth.
Yeah, I believe the you're catching me off guard here, but I believe the human rights complaint has to be filed within. I believe the limitations period is a year, but I will. I may have to double check that.
It is actually. I've just been through the application form. It's fresh in my mind. That's right. Anything else, Megan, before we wrap this up?
No, I think we've addressed the questions that are on the chat board for now.
And Bobby, we will be talking next week around consent to treatment for people who have capacity. So I'm really looking forward to that webinar. I think we're going to learn a lot next week. And then the week after that will be on substitute decision making. So if we're done, then I think we can wrap up, and I'd like to thank Brendan and Megan, and thank you all for joining us this evening, and hopefully you will join us next week. Goodbye, everyone.